And I want to thank everybody for making your schedules available. I know these are difficult times, but we're going to get through it, and we're going to meet our deadline that the legislature has imposed on us. And this morning we have three or four very interesting speakers. The first of which is going to be Justice Ann Timmer, who's Vice Chief Justice of the Arizona Supreme Court. And she's going to explain for us the Arizona merit selection system, and in particular, its unique nominating process. And then she's also going to explain a little bit about Arizona's mixture of nonpartisan and partisan elections. So Arizona has a very unique system, and we thought it might be helpful to have the commissioners hear what they've done, how they've done it, and what the reasons for it are. And then we also have James Tinley, who's Deputy Director of Enforcement of the Texas Ethics Commission. We've had a lot of our presenters already raise issues about campaign funding for judicial elections, and we thought it might be helpful to have somebody from the Texas Ethics Commission identify the various campaign and ethical rules with which our judicial candidates must comply. And so James Tinley is going to be speaking to us about that. And then finally, and this is getting a little bit of a jump ahead, and it really speaks to Senator Birdwell's point that he made at the last meeting, which was we've got to get on a timetable to make sure we have ample time to write and discuss and debate and come up with our recommendations. So we have Dr. Dottie Carmichael and Dr. George Nafel with the Public Policy Research Institute at Texas A&M, who frankly, we want to talk a little bit about whether they can be helpful to us in helping us put together our final report and recommendation. So we've got a full docket, as the judges would say today. Let's move on to the next item on the agenda, which is the adoption of the minutes of our June 5, 2020 meeting. I hope you all have had an opportunity to review those. Are there any changes anyone has to the minutes of our last meeting? If not, do I hear a motion that those minutes of our June 5th, 2020 meeting be adopted?
So moved.
Do I hear a second?
Second.
All right, it's been moved and seconded. All those in favor signify by saying aye.
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 All those opposed, same sign. The motion carries and the minutes are approved.
Chairman, can we call the roll real fast so we,
Absolutely.
for the record?
Next item on the agenda, somebody just added on. So let's call the roll.
Okay, Chairman Beck,
Here.
Senator Birdwell,
Present.
Senator Hinojosa, Senator Huffman, Senator Nichols, Representative Hunter,
Here.
Representative Landgraf,
Present.
Representative Menares,
Present.
Representative Sherman, Mr. Babcock,
Present.
Judge Jameson,
Here.
Chief Justice Jefferson,
Here.
Ms. Liberato,
Here.
Mr. Oliveira, and Chief Justice Phillips. Okay, we have a quorum.
Okay, excellent. Thank you. Item 5 on our agenda is the report on future public hearings. We currently have scheduled our first public hearing on July 29th from 10 to noon. And I know we've been working with Representative Todd Hunter's office to make sure that our meeting and our future public hearing in Corpus Christi is organized in a way that will ensure that we have as much public participation as possible. And I want to thank Representative Todd Hunter for his help and the help of his staff in helping us put this first meeting together. It's going to be a Zoom meeting, and so I think we'll learn from that. And whatever we learn from our July 29 first public hearing, we'll be able to use in our scheduling of any subsequent public hearings. But I really think we need to hold multiple public hearings in August so that when we get to September, we can start rolling up our sleeves and getting down into the nitty gritty of what our ultimate report and recommendations might be. So with that backdrop, let's turn this program over at present to our first presenter, which is Justice Ann Timmer, Vice Chief Justice of the Arizona Supreme Court. Justice Timmer.
Be here. I'm happy that you all are considering merit selection, or at least I'm happy to tell you about Arizona. So Megan, am I going to be able to do the PowerPoint from my computer?
Yes, you should be able to share it.
Okay.
If you see at the top, at the bottom of the screen, there's a green button that says share screen. So if you pull it up on your computer, you should be able to share it.
Yes.
Senator Hinojosa present.
Thank you, Senator Hinojosa.
So you're able to see, oh, I can do either of my screens. Okay. And I will do that. Terrific. All right, are you all seeing it then?
We can see you, but I'm having trouble hearing you.
Okay. Oh,
And we don't see the PowerPoint either.
Oh, you don't? Oh.
No.
These things never work, do they? Let me try screen one. You're able to see me?
Yes, we can see
Yeah.
you.
Okay, let me see if I can put the PowerPoint on that screen and maybe that'll work. Now do
Chairman,
you
back
see
to
it?
Robert Nichols.
All right, now do you see it?
No.
It shows on mine that it's showing. Well, Megan, you have it. Can you just go ahead and show
Yes.
it? Okay.
And it's the
I
text.
might, Justice Timmer, I might add that all the members of the commission have written, they have a copy of your printouts.
Oh, okay. Well, then great. Then let's just, you all can just look at that and follow along. And then if you like, that might be the easiest way to do it.
I'll have Kelly. Kelly, can you share?
I can share it.
Yes.
Okay, well, let's get started then. So the first slide, the way we do things in Arizona is we have a combination of ways that judges are elected. So we have the nonpartisan elections are in the Superior Courts in 11 of our counties. Arizona has 15 counties. So 11 of them are have a population less than 250,000, and they select by just nonpartisan elections. All of our justices of peace are elected in partisan elections, and our merit selection, which is by our Constitution, the Superior Court judges are elected in in 4 counties. Any county by Constitution that has a population at the decennial census of more than 250,000 people, the Superior Court judges are elected or proceed in merit selection. We have one right now that's 3 counties: Maricopa, which is Phoenix, Pima, which is Tucson, and Pinal County, which is becoming the greater Phoenix area as well. One thing that we do allow is that if other counties that have fewer than 250,000 people, if they nevertheless want merit selection, the voters can decide that they want it and opt into merit selection. So far in the history, since we've had merit selection since 1974, we've only had 1 county opt in, and that's Coconino County, which is Flagstaff area. And they just did that in 2018, first time they've done it. So I think that's gotten the attention of some of our other counties too that might want to start going to that. Our Supreme Court is, the justices are selected by merit selection, as well as our Court of Appeals, which in Arizona is 2 divisions. We have 5 nominating commissions, you can see. So we have 1 specially for the appellate courts, and then we have 4 for each of the trial courts, Superior Court judges. One thing that I think is a little bit unfortunate, which politicized our appellate court commission a little more, is that we went to having the independent redistricting commissions who draws the lines in our states. The people that do that are now selected by our appellate court commission. So you can see that as we approach redistricting, every time that occurs, things start to get a little more political on who's selected for that commission, not because of the judges, but because of who will end up on the redistricting commission. Each commission has 10 members, 5 attorney members, and 1 chair. The public members dominate these commissions. I've I chaired 2 of them since I've been on the Supreme Court. I've done it for the Maricopa County Superior Courts, the Phoenix ones, and the Tucson ones in Pima County. My experience has been that the public members truly do dominate these commissions in terms of they take this as seriously as people do when they're jurors. There's a great public responsibility, and they do not tend to defer to the attorneys at all, which I think is good. It makes it a very balanced process. It's always chaired by, technically it's supposed to be the Chief Justice. He always simply delegates that to one of the other justices, with the exception of the Appellate Court Commission, which is always chaired by the Chief Justice. Okay, membership. Who gets on these commissions? Our county supervisors appoint the 7-member citizen committees, and the governor also appoints a 9-member statewide committee to recommend members to each of these commissions. So we have county supervisors appointed for obviously the county Superior Court ones, and then the governor does a statewide committee for the appellate commission. The problem with that is, if you all are examining this, is that we have found that the Constitution doesn't put any requirements on how long a supervisor or a governor has to appoint. And as a result, we've really struggled over the years with having some of these positions filled. If you have a county supervisor that's not motivated, it could be left unfilled. We've found 4 years, and there's no backup to that. If I was going to construct that today, I would say that if they don't appoint within like 60 days, then the court could appoint something like that, because it has left gaps in these committees. So the state bar will recommend all the attorney members for all commissions. The governor has to appoint all members, and then the Senate will confirm each of those appointees. And each member serves for 4 years and may be reappointed, and they typically are. And if they're not, if there hasn't been a Senate confirmation of an appointment, then whoever had that place gets to sit on the commission, continue to sit until a new person has replaced that person. Okay, next. Oh, sorry, going back to the other slide, I wanted to point out that that quoted language there is important right from the Constitution, that the governor, the Senate, and the state bar must endeavor to see the commission reflects the diversity of the population. So you'll see throughout our Constitution and our rules, diversity is always mentioned. That, again, while merit's first, diversity is important. And that's been deemed in terms of gender, race, national origin, but also where you live, and in the rural areas versus the urban areas, that kind of thing. Okay, next. Budget. The Constitution requires that the commission and travel for the members be paid from the general fund of the state. And next. And currently, I know you're all interested in what it costs. Currently, our Judicial Nominating Commission budget is part of our JPR budget. JPR is Judicial Performance Review, and that's kind of the corollary to the other side to merit selection, which we have judges, when they're appointed by merit, they are then have to stand for retention on our ballots. And the voters pretty quickly said, well, we don't know who these people are. How do we know if they're qualified? So in our Constitution, we now have something called Judicial Performance Review Commission, which is a citizen-dominated commission dedicated to evaluating the judges at least every 4 years, but also when they're absolutely when they're up on the ballot. And then they will actually evaluate the judges. For example, they will, for Superior Court judges, everyone is for over a 4-month period given surveys about how the judges performed, the employees, the witnesses, the jurors, the attorneys, other judges, to rank them in a number of areas. And then all of that is discussed. Sometimes they'll have, if there's a problem, a judge will have to come forward and testify before the commission, and then the commission, about 30 people, will recommend to the citizens whether the person should be retained or not. Every voter is mailed a pamphlet with all of those results, and there's a website for it too. So the Judicial Nominating Commission budget is part of that JPR budget. Currently, as you see, it's over $500,000, about 3.5 full-time employees staff those. Arizona, obviously a much smaller state than Texas. We have about just under 8 million people, so that gives you a rough estimate for how that would compare to what Texas might need. So next, nominating process. I wanted to point out that we have uniform rules of procedure that really get into the details of what the commissions have to do. Those are approved by the Supreme Court and revised every so often as need be. I think I've given you, Megan, a copy of those. In fact, I've given Megan a copy of more information than you'd probably ever want about Arizona's process. We think we've given you the rules, the constitutional provisions, a few presentations, the applications that have to be filed by the applicants, as well as if you want to see what it looks like, there are some videos that explain the process. I think we have Sandra Day O'Connor is in there, and who is a big proponent of merit selection, and it'll actually show you how the commission works. And then we have, I think I gave Megan, I also gave you the recent interviews for Supreme Court nominations, at least, so you can actually watch online as much as you want any of the interviews of applicants to get a sense of it. So she has all of that. So what happens? So if somebody resigns their position and there's an opening on one of the courts, any of the courts, the commission has 60 days to nominate someone to the governor. So you have to get this process going very quickly. If it doesn't make the 60-day deadline, the governor can appoint anyone he or she wants to do. So what happens is as soon as there's an opening, the commission says there's a vacancy. Here's when the applications are due. Here's where they can be found. They're all online with the Supreme Court. They're all now in fillable format so that you just submit them online to the court. You'll see if you look at the application, they're lengthy, they're detailed, and they're a public record, which is something that we tell people that there are some information can obviously be redacted, like your social security number and some other things, and you can opt into confidential information. For example, if it would reveal any client information that really shouldn't be revealed, possibly trade secrets, if you're describing some litigation, that kind of thing that you've been involved in, you can opt to have it in confidential. But for the most part, it's wide open, and people can go sign in online and look at your application. So I tell people when you're applying, you really are putting your personal reputation out there, because there it is for everybody to see and for people to comment upon. So that, as I say, the names of the applicants are released to the public, and they're affirmatively invited to submit written and oral comments about the applicants. Next. There are, there's the evaluation criteria. That's really just taken from the application. It gets into various things, so you can see if we look at it. Next. Okay, you can just put the whole slide up. Yes. Oh, before that. So the commission, when you get the application, some of the commission personnel will do some investigation they'll look up professional discipline and any criminal history records, and that will be reported to the commission. And then the commission will affirmatively seek comments from everyone. As a practical matter, this is what happens. It's like a campaign, I always think, but it's simply on a smaller level among the commission members. The commission members' names and contact information are on our website, so and email addresses, that kind of thing. So what happens is that candidates will solicit their friends, supporters, whomever, to contact commission members to lobby them, if you will, for here's our, this person would be great, or that, and why. And the commission members can take in all of that information and do follow-up calls if they like. Usually they just gather up all the emails and such and take note of it. Next. There are 2 meetings that the commission will have in any application period. The first meeting is the screening meeting to see, okay, who do we want to even interview? So now we have all these applications, we have all these comments from people about them. We know the criminal history, the discipline history, we've read the applications. So now let's talk about it. All of these meetings, they're generally held if they're in Maricopa County or for the appellate courts, it's going to be held in the Supreme Court's building. If not, they'll be held wherever, obviously in the counties where the judge is being appointed. The public is invited to come, so they're given notice, and people do come. It's surprising how many people will come. Not only people that are disinterested, people that support the candidates, sometimes people that don't support the candidates show up. And then you will generally have what I call the watchers, people from the specialty bars, the Black Bar Association, the women lawyers, the Asian American lawyers, etc., who are there taking notes. They want to ensure, is this a fair process? Do they think that any one group is being overlooked, that type of thing. And they also like to write down the questions, I think, to then share with their membership who might be applying for the job in the future, just to say these are the types of questions that they're asking for future application periods. The first thing that will always happen is public comment. And if public comment for us started to get out of hand, because again, people, unfortunately, the candidates themselves started asking their supporters to come forward and speak on their behalf. We were getting too many of that. So we actually changed the rule to tell candidates that they cannot solicit more than 2 people to come forward to give comment, because it just, they'll just take over the meeting. In Maricopa County, for example, with so many judgeships open, when I shared that one time, it maybe like 2-hour comment period, 50, 60 people. It's just too many people. So we really try to limit that. And I recommend that you think about that if you get to that detail of limiting how many people can be invited to come. Generally, I would always put 2 minutes and stick to it. You have 2 minutes to say something. But that's an important part of it, the public to be heard. Not only the people who support, but sometimes you get detractors who show up. Particularly if they've already been judicial officers, they'll come forward to say this person was a terrible judge and he or she bungled my case in this way, it wasn't fair, didn't listen, that kind of thing. So sometimes you'll get there, by the way, you'll get there that in advance, and as a chair, you might want to give the applicant advance notice of that kind of criticism, but I'll get to that. So after the public comment, we will then discuss the candidates in the public forum. So people take notes. A lot of times that's when if there are problems, I think it's important that you actually air that, saying, well, this person maybe doesn't seem to have sufficient experience, or they don't have enough jury trial experience, or whatever it is, and that word will get back to the applicant for the future. But eventually we'll get down to a vote, and we'll vote who we want to interview. And why don't we go to the next one? We'll invite people then to be interviewed. Next slide, please. And this will result in about a couple weeks later, usually we'll have the interviews. Again, we'll start with public comment. What do you think about these people, that kind of thing. And then we will interview folks, generally the same questions in about 20, 25 minutes. When I say generally the same questions, once in a while, as I say, there might be some real concerns about an applicant, that we've received information that needs to be looked into, and at least give the courtesy to the interviewee to ask about it. So we'll ask about it, and generally it will fall to the chair to ask the uncomfortable question, something a lot of times along the lines of, well, in a much nicer way, obviously, but essentially, we hear you're kind of a jerk. What do you think? You don't work well with people, that kind of thing. But this is your opportunity to respond. I found, oddly enough, that more often than not, people turn that around and do a terrific job and really sell themselves to the commission if they have an opportunity to address negative information. But that negative information and getting that out there is very important. And even though we have executive sessions, I've always told my people it's not Executive session doesn't mean that that's a place just to share negative information. That needs to be out there so people know it's fair and know it's being addressed, and give the candidate an opportunity to address it. Executive session really should be for very confidential things and setting the questions and things like that. So next slide, please. Okay, so we have to nominate at least 3 people by the Constitution. No more than 2 can be members of the same political party, and if it's more than 3 being nominated, no more than 60% can be members of the same political party. And then we list them in alphabetical order. The reason for that in the Constitution, obviously, to have some type of balanced political list. As a practical matter, what we have found is that whoever the governor, whatever party the governor is, tends to favor his or her own party. We've really emphasized over the years to the governors that we've had that if you're going to kill merit selection, if you only appoint people from your own party. Because why would you go through all of this bother if you're from the other party that will never stand a chance? And then you don't have an ability, as you can see, to send up a list. So it's a little bit of a process to work with your governors on this to make sure that they will cross the line in some of their appointments. Otherwise, this won't work. We have found, and I've been on the Supreme Court for 8 years, and before that, our Intermediate Court of Appeals for 12. So in the 20 years I've been on the courts, the governors have been pretty good about that with some variety. But what I found is they've been much better at the trial court level and not so great at the appellate level, and terrible probably at the Supreme Court level. And that is a problem that we are constantly facing. So as on the Supreme Court, sometimes when we approach an appointment, we now have a Republican governor. We're out there trying to drum up some Democrats, some qualified Democrats. Please apply. That's how I first applied to the Supreme Court. We had a Democrat in office. I'm a Republican. They were hearing no Republicans were going to apply, and I was persuaded to do it, saying, "Hey, you're not going to get this." And I knew I wasn't going to get it, but you might get the next one when we have a Republican back in office. And it varies, which was true, and which is what happened. So that's a downside of this process, is that you can't say it takes politics out of it, because it doesn't. And so it's something that your Supreme Court really has to work with the governor's office to ensure it works. So next slide, please. Okay. Here's our average applications per opening. You can see for the different Superior Court and appellate, not as many as you'd think. I was surprised when I saw the numbers when I asked for them. So I thought Maricopa usually has a little more. Maricopa County has 98 judges, so there's always rollovers. There's constantly applications going, and because there are always applications, it seems like, going on, we have what we call rollovers. So we won't make people apply every single time. We ask that they update within a particular time period with new information, but I think they can go for at least a year without having to resubmit, and can just let it roll over without unless they affirmatively withdraw, which is a pretty good idea. And by the way, I think with this process, because it's public and because you really are, risking your reputation a little bit, and it is an onerous process, I think that does drive down the number of people that really self-select, particularly the higher they go. The appellate, they seem to really self-select. I have chaired most of our municipal courts follow this procedure. They're not required to, they just adopt it. And I've been on some municipal selection committees, and they'll get like 85, 90 applications, which I find interesting compared to the state courts. Next slide, please. Okay, after the commission meets, so now it all goes to the governor. The governor gets all the applications, all the comments, everything. The governor now has 60 days to appoint, and if the governor does not do it, then the chief justice gets to make the appointment. That has never happened. That will never happen. But it goes up to the last day that the governor really watch it to make sure that they don't lose that opportunity. But that was something that early on in merit selection in our state. We had governors sit on these appointments, and it was mimicking the federal system where you could go for a long, lengthy period of time with unfilled positions, and the state courts just couldn't abide that. So the populace amended the Constitution to require this 60-day time limit, and that's worked great. So that means we've never had an opening more than 120 days, which keeps it going. So I really recommend that you have something similar to avoid what happens in our federal system. Again, now you're back to the names of the nominees are public. Citizens may contact the governor, and they do. It's another lobbying. It's another chance to take that same lobbying business up to the next level, and that's what happens. Oh, and then the governor, by the way, will have you in to be interviewed. Depends on the governor. Our current governor has their staff interview first, and then has the nominees come up and interview with the governor separately. And if the governor has seen that applicant before and recently, many times opts not to give a separate new interview, just remembers it from last time. So while that's scary, frankly, I think when I was in the Court of Appeals, I was interviewed by our governor and didn't get the position, but 2 months later, another opening, and I got that one, but she didn't re-interview me. So they have the option to do that kind of thing. Next. Okay. After appointment, then the judge or the justice is on the bench for 2 years, at least 2 years, and then you have to be on a retention election. I think it's 2 years after the next general election. So sometimes it can be a little longer. So you're up for retention, and then if you're retained, Superior Court judges get 4 years, and appellate gets 6 years. Next. I think we're towards the last. Yeah, this is towards the last one. One thing that we have found is then if you do, we have judicial performance review, which I explained to you already quickly, and retention elections. What you'll have to do if you have this kind of system is educate your voters, because voters don't have a clue, and we see that you have voter fatigue and filling out these ballots, and they just skip it, which then retention doesn't work either. So the courts have really had to work with trying to educate the public in various ways, and this is one of them. So if you can press play, this is just a minute and a half. Is it playing? Oh,
Is the audio not working?
I guess the audio is not on.
Let me try. Can you hear yet? No?
No.
No, it's not. What it does is simply, this will give you an idea. It's just some of the things that we do to educate the public about what merit selection is, what retention is, where they can find information about judges, and what it means. So we found that the voters are getting more educated on this, and we've had some judges. Most judges are retained by far, which is not a surprise when you have to go through all this merit selection. But once in a while, if the commission says, no, this judge really isn't a good judge, and we recommend that you do not retain that person, then the voters are paying attention, because they are not retaining those judges. And so
I have the audio working now if you'd like to play the video.
If you'd like, or I know I'm coming, go ahead and do it. Just a minute.
Voting is important. I mean, we all know that. After all, it is the foundation of our nation. But before you put on that I voted sticker, answer one question. Did you finish the ballot? Now, you probably voted for the president, maybe the governor, even the mayor. But what about the judges? You see, in Arizona's 3 biggest counties, Maricopa, Pima, and Pinal, judges are chosen through something called merit selection. It's a system that finds the people who are most qualified and then lets the governor make the final decision. It served Arizona since 1974. But while the governor chooses, you decide whether they stay on the job. You see, the judges face something called a retention election. It's a simple thumbs up or thumbs down by you, the public. But how do you decide? Well, Arizona voters created something called Judicial Performance Review. Judges get judged. They get judged by the public, they get judged by lawyers, and in the end, they get a score. High enough? Well, it means thumbs up. Too low? Thumbs down. So, where do you find this score? Easy. Just go to azjudges.info. You can quickly find whether judges met the standards or not. It takes just a few minutes. And when you're done, you can wear that I voted sticker with pride because you finished the ballot. You want to learn more? Just go to azjudges.info.
Okay, and that,
Using how to.
sorry, that's it. I know I spoke very quickly and gave you a lot of information. Are there any questions that I can answer in the allotted time to me?
Judge, this is David Beck. First of all, I want to thank you for taking the time to make this presentation. We had a chance to look at some of the materials ahead of time, and I think you explained well the various steps that one must take to become a judge in Arizona. But let me ask a question a little bit about the history. I know about the Modern Courts Amendment in 1974, but am I correct that before 1974, Arizona, for the most part, elected your judges? And if that's the case, were they partisan, nonpartisan elections? And then a related question is, what caused the impetus for the 1974 Modern Courts Amendment?
They were partisan elections prior to 74. And what caused the impetus? Well, if you look, there was actually a wave that went across the nation in the 60s. So about 10 or 15 states that went to merit selection did so about the same time frame, late 60s, early 70s. So I think it's one of those things of one state following the other. I'm not sure which one. Missouri gets a lot of the credit for that, the Missouri system, but then other states start looking at it, as we're apt to do, and think, well, that's a good idea. Interestingly, the big proponent was Sandra Day O'Connor. While she was a senator in Arizona, she introduced the legislation to try to get this on the ballot, and it failed ultimately. But because of that efforts, after it failed in the legislature, then the people decided, to get it together and put it on the ballot as an initiative procedure, and it passed as an initiative. The irony is she never got to take advantage of it. She still had to run for election for the Superior Court in Arizona. So she just missed it for that. But then she did, she did get to take advantage because then our governor appointed her to our Intermediate Court of Appeals through the merit selection system. So that's how it came about. I think it's just a wave from other states.
And the initiative that was put before the voters, was that a real close vote? Do you recall?
Oh, well, it was way before I could vote, but I don't recall. I can find out for you, though. That's something that can easily track down. And it was, that was what, 1974. And as I say, the flaw in it came about with voters not knowing what to do. And that's why it wasn't until I think 1979 that a new initiative came for judicial performance review. And somewhere in there as well became the Judicial Conduct Commission, which is the one that oversees the ethical, doings of judges. And that's a separate body from the court system that's outside the court system that will do discipline and that kind of thing.
Yeah, well, thank you very much. I think, as you know, Texas, we've elected our judges for a very, very long time. Mm-hmm. And so one of the things as a commission, we've been asked to look at is whether, frankly, we just continue as is, or whether we go to, systems similar to Arizona's and so on. I've got a number of questions, but I don't want to, I want to allow time for other commissioners to ask, but just one point to clarify, the judicial performance review, that takes time. And is that part of the budget that you told us about that was roughly $500,000? And I know it's part of the general fund. Does the legislature have anything to do with the allocation of resources to any of this merit system that you've told us about?
The answer is yes to both. The budget includes the judicial performance review, and because it comes from the general fund, the legislature has to be the one that funds it.
Okay, thank you. I'm sure other members of the commission have questions. Let me turn it over to other commissioners.
This is Senator Hinojosa, if I may. I was looking over the charts, and thank you very much for your testimony, Justice. I think it's very informative, very, very well organized. But I'm looking at your number of appointments of appellate and superior court judges. There were 162 appointments. Out of the 162 appointments, 11 were Hispanics, 140 were white. Then I think 110 were other. My question is, has diversity ever been an issue in the appointment process?
Yes, absolutely. I think diversity is always an issue. That's something that, and I think what I sent you was the PowerPoint that went over all those numbers and that kind of thing. It is always a concern, and that's why, as I say, the Constitution says merit number one, but diversity has to be a consideration. In my view, and this is just my personal view, and I think it's a little bit of a flaw in the Constitution. Well, what does diversity mean? Because I think diversity in that terminology has been hijacked a little bit. I assume what they originally meant was gender, race, national origin, that kind of thing. But I've heard many candidates say, oh, diversity equally is, well, my background and where I live, and I come from a rural climate, that kind of a thing. And I've had commission members who've said, yeah, that's what diversity means as well. Personally, I think that your experience is all of those things, but diversity is something different. But that has been an issue that our commissions have talked about. One thing I did not mention is I can't remember if this is by rule, I think it's by rule. All of our commissions, the 5 commissions that we have, meet at least once every 2 years. It used to be once a year, but now it's once every couple of years. And we'll have a full day of either presentations and discussions, and each time that's a topic of what does diversity mean. And people have different views on that. And so if I was doing this from the bottom up, I think and diversity was important to me, which it is. I think I would define that a little more definitively to address that. We've also had to go out and trying to get people from the different organizations to apply. We've had a lot of difficulty, particularly with African Americans. We don't have a lot of African Americans in Arizona or as judges or as lawyers, and so that's one thing. But we do have a lot of Latina and Latino, and there's been some suspicion in that community that they're not going to get through. So I always tell them, but you got to apply to get through. So there's been a lot of working with that. But in the commissions themselves, and I think that's what's important too, that when you have these public meetings, those discussions will happen in public. That usually it's the chair will say, well, we need to consider, of course, what about diversity? And we don't have a very diverse list, and we need diversity on our list. And so those conversations go on in public, and I think the fact that it's public encourages them a little more than maybe they would if they weren't in public.
Thank you for your answer. And I understand it's always an issue when you have proper diversity or not. I certainly would include women, and they seem to be pretty active in Arizona, which is good. In many respects, they make very good judges because they have a different perspective of issues. So thank you.
Sure. Well, and I will say though, if you read, and there are a lot of law review articles out on this, and I should send you one that's actually written by one of my former colleagues on the Court of Appeals. There's a law review article on diversity and its effect in merit selection. And the conclusion that she came to was that that at least women actually do better. I can't recall what she said about minorities, but women do better in partisan elections than merit, which was a surprise to me. But it's I'll send you the, I'll make sure, I'll send to Megan the article. It was, I think, in the San Diego Law Review or something.
All right, any other
Thank you.
questions from members of the commission?
Chairman Beck, can I ask the chief, during these retention elections, are there funded campaigns from interest groups that seek to deny retention, campaign commercials and that sort of thing? And then secondly, do the judges themselves campaign? Do they go across the state and make the case for their own retention?
No, for the most part, to answer your last question, judges do not campaign. There's really no need, and it's a real relief. But if there is some kind of a challenge, sometimes there's an interest group, an unhappy group that, starts putting up, I recall this last one on one judge, that whoever was very unhappy and put little vote no on someone. That if that happens, or even if it doesn't, the judge, if he or she likes, can form a campaign committee and follow rules to put something out there on it. It happened to one of my colleagues. I didn't think it was necessary, but he did it anyway on the Supreme Court because he got some negative pushback because of a case that was decided, and he happened to be up for retention. So he got nervous and got advice and went on the radio, and it was all for nothing, and spent some money that wasn't required. But they do have that option if they wish, but it is very rare.
Thank you.
Chief Babcock has his hand raised.
Yeah, thanks for noticing, Megan. Justice Timmer, thank you so much for being with us and spending your time. I've got two questions. One following up on Senator Hinojosa's question. Is there, other than an aspirational effort made to create and have diversity of your commissioners, the people that are charged with nominating, are they diverse? Is there a diversity on your 5 commissions? So that's one question. And the second question is, as we're trying to create a system, if we do recommend deviating from the status quo, and we look at Arizona, is there some set of problems or things that we should try to avoid? I know you've mentioned a couple, keep politics out of it, and as you noted, that's hard. And then the time that the commissioners would serve, I got that. But is there any other big things we should be worried about? But first diversity, and then big problems we should worry about. Thank you.
Well, diversity, gosh, I'm thinking, I haven't looked at the commissions in a while. The 2 that I just had chaired in the last 5-6 years, diverse with men and women. I didn't think is diverse enough with racial minorities. Had some diversity, but could use more. And I know that on the one that I last chaired, Maricopa, we had an African-American woman attorney, and the governor appointed, and the Senate refused to confirm her. So that was a kind of a wound, because as I say, we don't have that many African-American attorneys in the first place, and then to not be confirmed. And she wasn't confirmed because they thought the spot should go to a Democrat woman, and she was a Republican, and so they kicked her out for that. So that was problematic. But that's going to happen to give the Senate their opportunity to weigh into these things. They can do that. I think in terms of any problems to avoid, I've mentioned a couple. Our biggest problems, and particularly since you all know obvious interest in diversity, is getting enough applicants. So you can't have a diverse bench without people applying that are diverse in the first place. And so, for example, I get all the time, there are 7 justices on the Supreme Court. I'm the only woman. And now the governor has appointed, the last 5 appointments have all been men. And 2 have been Latino, so that's good. So the first 2 ever on our high court. But we really are lacking in women. And so the women groups I go to are, complaining about that. How horrible is the governor for not appointing women? Well, let's look at the last few applicant pools. You've had on one, it was 1 woman out of 15 or whatever, or 0. So you have to apply to be considered. And we've been having that issue at the Superior Court level with Latinos as well. And Latinas, they haven't been wanting to apply. So how do you overcome it? I don't know. There's no way to enforce a rule that makes people apply. I think that what you need to make sure is that you set a system up that people think that it's fair, that you frankly lobby to your governor about the importance of merit selection, that you have to be diverse. And you can deal with the governor's attorneys or the governor directly about that. I know our chief always sat down with the governor one-on-one and made that pitch, saying we need to have a diverse bench for the people to be respectful. Then you get people to apply. And I found that to be true, that once someone was appointed that was diverse, all of a sudden the next appointment you get more people. And so I think that's important. And I also think it's important for your Supreme Court to go out to these groups and talk to them and encourage them to apply and say, yeah, you'll get a fair shake. We want people. And, people will hear that as well.
Thank you.
Mistakes, I'm sure there's plenty, but, but I think that's all I can think of for now.
Thank you so much, Your Honor. Thank you.
I think Justice Jameson, Judge Jameson had a question.
Well, I think you're muted.
I think you're muted, Martha.
Aren't you glad? Anyway, thank you. Thank you, Justice Timmer, for being here and helping. And this is a tiny little question, which is, I see that the commissioners serve 4-year staggered terms. At the conclusion of their terms, I know they can be reappointed. Do they go through the same procedure that they had to the first time round to get on? And are there commissioners who have served and served and served for a long time?
There are commissioners who have served and served for quite a bit of time, but I don't believe there's a limit. It's just up to, does the governor want to reappoint that person? And they do not have to go through that system again of having like the county supervisor nominate or that kind of thing. However, the county supervisor could nominate someone else then, and the governor could select that person instead of who had served before. So,
but it's initially the governor's idea, let's say 4 people, I'm just out of the, 4 people are up, their terms are expiring, and the governor has the choice whether to reappoint or not.
Correct.
And it's only if he chooses not to that the process starts over.
Yes. I'm hesitating because I think that someone could probably, it doesn't happen very often, but I think like a county supervisor could decide, well, I want someone else, so I'm going to also nominate someone else. But usually they'll just call up the governor and say, we don't like the job this person's been doing, so let's replace them. Although my experience has been the county supervisors just don't pay attention. They just, some just don't care. And you can talk to them. I've called them up saying, you've got to make an appointment, and they just don't do it. So I would change that rule, saying if you don't do it, it's your right to do it, but I take it away if they don't exercise it.
And how many people are on, can the term limits of can that alter a majority of a commission? Like would ever a majority be up for reappointment at the same time?
Oh, no, I don't think so. It's you're asking a little bit more detail than I'm aware of, but if you really want to know, I can get you some of that information.
Oh, that's okay. But I mean, how many people are on, and they probably are different, but how many people are on, how many commissioners are on one of your 5 commissions?
You have 16 altogether that includes the chair, so 10 public, 5 lawyers. And generally, just anecdotally, there's usually about 3 or 4 up at one time. And it's not uncommon that they just haven't been confirmed. Senate hasn't gotten around yet to it, and they just kind of linger sometimes for a lengthy time. The ones that the governors seem to balk at most, or whoever is nominated by the bars, the state bar, because they're usually not political type appointees, and so the governor might not like that person. So that's not uncommon just to reject whoever the bar wants, and so that's a back and forth that will happen quite a bit. The governor's public members, I notice, tend to be people that have the governor's ear. So that's probably why we like to have the lawyer members too, so that, it's a mixture of people. But I have found, as again, I compare them to jurors, that sometimes the governors will appoint, their best buddies, but once they get there and realize the importance of what they're doing, they do the right thing and don't necessarily do the governor's bidding. Usually the governors are complaining they want larger lists, because governors, they like the merit selection, they figure it out. They might come in wanting voting, but then they quickly figure out they have more power if they're the governor, if they get to a point. So, but they want large lists. So they're constantly telling the people that they appoint, send us, as many people as you possibly can, so that we can have a bigger selection. And they get very upset when you send 3, that kind of thing. And so, but that will happen. I've noted the commissions will do, if they don't have 7 or 8 really qualified people, they'll send 3, despite what the governor wants.
Okay, I think Representative Manetta's had a question.
Good morning, Justice Timmer. Thank you for your time this morning. I really appreciated your presentation.
Sure.
I had a question, something you mentioned regarding when applicants are screened and then they move on to the interview portion. Say, for example, my dear friend Todd Hunter decides to move on from the legislature, apply under the system, applies to become a judge. You mentioned, there was something that caught my attention. You mentioned if you bring people to talk on your behalf, because of the sake of time, and we all know how public hearings can last a very long time, that they're limited to 2. What about those that are in opposition of the applicant? Are they limited as well?
Yes. Yes.
Okay.
That's up to each chair, the way they do it. And the rules talk about limitations. And the way I usually do it, I do what I call, work the crowd beforehand, whoever's there, talking to people. And I say, we've got a lot of business to do, so I'm going to limit. And I'll tell them, please listen to the person that's gotten up before. And if they've said, Todd Hunter is the best thing since sliced bread, it's okay to say the word ditto. And not have to say it again, or that kind of thing. And I think that when you do that, then I think people understand you're not just trying to cut them off. Now, when the people that come up and the negative people, which especially happens in Tucson, for just that's really, they get riled up in Tucson, and a lot of family law people want to come forward to talk about that. And so I think if you talk to them beforehand, hear some of it, try to direct them, to let them know that I understand it. They've submitted something in writing anyway, and I encourage them to do that, but that they have to keep it to 2 minutes. If they're on a roll, I don't cut them off like that generally, but I have the staff member next to me. I tell them, raise your hand at 2 minutes, and I ask you to stop, and I haven't had any problem at all with people.
And in terms of the judicial performance review portion, I had a question. If a judge has an issue with the scoring, maybe they don't agree, they got scored low, is there a due process portion that they can challenge that scoring, that they have an opportunity to address something they feel that they weren't fairly evaluated in?
Yes, if they're getting poor reviews, then the commission will write to that judge saying, you're getting poor reviews. So you have, we invite you to come to the commission. And again, it's a public meeting, and essentially explain, why you should be retained, or do you have a reason for some of these scores. Family law lawyers, if you're unfortunate enough to be on family law assignment, we have rotation here. When you get rated, we always know your scores will be lower because nobody is happy in family law, no matter what happens. So it always tends to be lower, and the commission understands that. But sometimes especially when they get something back about the judicial demeanor of the judge, that seems to be the big thing. Lack of communication, not addressing people well, or judicial performance review goes through all of the biases too. Is this person biased against, rate them on women or races, whatever. So they'll invite them in, they get to talk and they get to explain themselves. And that usually is the best, that's all the due process though they're going to get at that point.
Thank you.
I think Senator Huffman had a question, and Justice Timmer, I might mention that before Senator Huffman became a senator, she was a judge. Senator Huffman.
Good morning. Thank you. Thank you very much, Judge. You've really, I think you've given us very frank discussion this morning. I know as members of the commission, we all appreciate that very much, which is exactly what we need. A couple of things though have been, as I've listened carefully to your testimony this morning, a couple of things have come to mind. Am I correct that your procedure in Arizona has been going on since the 70s? You've been doing it that way. Did I get that correct?
Yes, 1974.
And so I think what one of the concerns I have as I listen to you is that you have continued to say, and again, I appreciate your frankness on this, that politics continue to play a large role in this process. So one of the reasons we're here and one of the reasons we're examining, I think that we're thinking about or examining the idea of changing the way we do this in Texas is to try to get politics out of the process. But several things you've said, you talked about the governor, of course, wanting to keep his power. We all understand that, no matter who the governor is or what party he may belong to. You talked about the governor rejecting maybe the applicants from, or those, whoever the bar association supports that he is, or she, I don't even know what your governor is, has rejected that candidate in the past, that the appointees that the governor has made tend to be appointees who have the governor's ears. You gave your own very personal example of you knew you weren't going to get the appointment the first time you applied, even though you're obviously extremely qualified and turned out to be a great judge, but you weren't going to get it because who the governor was at the time. Then you got it the next time when the parties changed. So I just point out to the members, listen to what she's saying. Maybe there's a way to fix all this, but you've been very upfront with us. You also told us that there are very few women on the Supreme Court. That's because there have not been qualified candidates who have applied, which again was one of the purpose stated why we were looking at this, to try to encourage more qualified candidates to want to become a member of the judiciary. But again, it doesn't appear, even though you've been doing this since the 70s, you are still not consistently getting those very qualified candidates that we want to serve in the judiciary. So I appreciate very much your input this morning. And I just bring these points up to the commission because I promise you're going to hear all of this again. And I think it's something that that we all need to be thinking about and to talk about how we could do it differently if we are seriously considering doing this, because I guarantee we're going to hear all of this again. But thank you so much for your presentation. Appreciate it very much. And thank you, members.
Oh, you're welcome. I will say that it has gotten more diversity on the Superior Court. I do think you're right about the higher you go in the Supreme Court. I am the fourth woman ever on our Supreme Court. So that tells you something. But Superior Courts sort of do pretty well.
Well, I was the 13th female senator in the history of Texas, so I understand.
So you know what you know.
I think the other women here who have been elected to office understand as well. Thank you very much.
Thank you, Senator Huffman. One last question, Justice Timmer. I know that your Constitution talks about the primary consideration shall be merit in the selection of judges. And my question really is kind of an overarching one. Using that as kind of the overwhelming parameter, if you will, how has Arizona done, in your view, in terms of selecting judges and having them on a merit basis and having them really meeting that standard?
I think we've done very well in that regard. As an appellate court judge, of course, I review opinions from people who are selected from all different ways, or from merit or from non-merit. Overall, I find that the ones that are selected by the merit ones have done a little bit better, a little more qualified. as opposed to some of the ones locally that have been elected. That, so not to say that sometimes, obviously, there are terrific judges who are elected in partisan elections. I'm just saying as a whole, percentage-wise, sometimes there's a lot more catch-up that needs to be done by people who maybe don't have the experience. Some of the ones in merit have already proven that they have risen to the top and have that kind of experience. I also find that, while not perfect, I think that it has delivered a bench that might not be delivered in the same way if you had, at least in the most populous counties, partisan elections. The way that they've gone with fundraising and that kind of thing, it's taken that element out, which has been a real relief for a lot of people. But it's a bench that not to brag, but I think that nationally has been a lot of innovation that comes from Arizona, things that people have done and haven't been shy about doing, things like jury notebooks, jury questioning of witnesses, lots of innovation. And this state, the judiciary at least prides itself on, why not try something new, not just to do something new, but to make things better. And there are not a lot of concerns in the background of, oh wait, I have to run for re-election and I'll have an opponent who will be pointing out some of these things. And so I think that has really taken some of that pressure away.
Okay. Well, listen, thank you so much on behalf of the commission for taking your time and putting together all these materials for our consideration. With your permission, we may want to come back to you for clarification of certain statements that perhaps were made or submitted, and maybe even to try to obtain some additional information from you, if that's agreeable with you.
Absolutely, and I would recommend that if you ever, if you really want to get to the nitty gritty, it's the staff people that do all of that. And I'd be happy to either have, I know Blanca Moreno is the person that knows everything, and either have her with me or individually for you to answer some of those questions as well. But it's a pleasure, and good luck to all of you.
Okay, thank you so much, Justice. All right, our next presenter is James Tinley, who's Deputy Director of Enforcement of the Texas Ethics Commission. We've had a lot of questions raised by earlier presenters about money and politics in judicial elections, and some of the problems that presents, one of which is the potential appearance of impropriety. So, Mr. Tinley, let me just turn this over to you, and we'll go from there.
Mr. Chairman and Commissioners, it's an honor to be invited to provide you, and it'll be work. And I want to start off by saying, my goal is to explain the laws and regulations that exist today for judicial campaign finance, and to give you some of the data that we were able to pull from our campaign finance database to give you an idea of how much money is being spent for certain judicial races. But just to be perfectly clear, I'm not making any particular policy recommendations for myself or on behalf of the Ethics Commission. It's simply information that you request to help you with your decision making. And with that, I'll begin my presentation. Let me share screen. Okay. So what I want to talk about today is just some background about what the Texas Ethics Commission is. We're the main regulatory body for campaign finance for all candidates in Texas, and also specifically judicial candidates. Get into some of the general reporting requirements, the rules that are specific to judges running for election, and then I'll show you some of the facts and figures I was able to pull together, and hopefully I'll have time to answer any questions that you might have. And if I don't have the answer today, I'll be happy to follow up with answers to your questions. Now, the Ethics Commission was created in 1991 by constitutional amendment. Most of the laws that we administer, or sort of our marching orders from the legislature, come from Government Code Chapter 571. And the commission is comprised of 8 members. 4 are appointed by the governor, 2 by the House Speaker, and 2 by the Lieutenant Governor. And these appointments come from lists provided to those appointors from the Democratic and Republican caucuses of the legislature. So you end up with an even number commission, 8 members that are evenly divided between Republicans and Democrats. And on top of that, it takes 6 votes for the commission to do just about anything of consequence, including adopting rules or really making any decision in a complaint. And that requires bipartisanship. And in my experience, the commission has worked hard to reach consensus. And if you watch the commission meetings, most of their votes are unanimous. Now, when they're taking the votes, what they're doing is they're administering and enforcing these four main bodies of law, starting with campaign finance and Title 15 of the Election Code. The commission has interpretive jurisdiction, although not enforcement jurisdiction over chapters 36 and 39 of the Penal Code. And that's where you have bribery, prohibited gifts, general crimes against public administration. So the commission can issue advisory opinions regarding those laws, but they can't enforce those laws. And those laws will be applicable to judges and any other public servant. The lobby law will not apply to judges at all, so we won't talk about that today. And then finally, the Chapter 572 of the Government Code has to do with personal financial disclosures and conflicts of interest. And anyone, all the members of the legislature who are on this commission understand the personal financial disclosure forms that they are required to file, and the judges have to file those as well, or most of the judges. The general idea of campaign finance, especially in Texas, is regulations through disclosure. This was first recognized, or at least recognized in 1976 by the Supreme Court in Buckley v. Vallejo, that says disclosure requirements deters actual corruption and avoids the appearance of corruption. And in that case, they quoted this sort of famous quote from Justice Brandeis, that publicity is commended as a remedy for social and industrial diseases. Sunlight is said to be the best disinfectants, electric light the most efficient policeman. This carries through in Texas, where the last Sunset Advisory Commission report referenced the idea that given the few limits the law places on campaign contributions and expenditures, Texas's approach relies on disclosure to shine a light on financial activity. And while that is true, and it's broadly true for candidates in general, there's additional requirements and additional restrictions above and beyond just mere disclosure that apply to judicial candidates. And specifically, there are contribution limits for judicial candidates, that a multi-tiered contribution limit approach for judicial candidates, which I'll get into. Now, this sunlight, this public disclosure comes in the form of campaign finance reports. Title 15 regulates the accepting, spending, and reporting of money in political campaigns. And this will apply to candidates, office holders, political committees, so groups that have as a principal purpose spending money in elections, or also independent expenditures. So people, or what we call in Texas, direct campaign expenditure. So those are individuals or corporations making expenditures expressly advocating for the election of certain candidates. That in many instances, those would have to be reported. And there are civil and criminal penalties for reporting violations. And it's important to recognize here that the campaign finance laws are not at all related to ballot access. So if a candidate runs and doesn't file any campaign finance reports, they could face those civil and criminal penalties for violations, but they would not affect their ability to be elected and hold office. And the commission also only has civil enforcement authority. So we have civil administrative hearings where we can issue civil penalties for violations of Title 15 of the Election Code. Now, an election starts with a candidacy. And in Texas, a candidate is any person who takes an affirmative act to gain election or nomination to elective office. And the first thing they're supposed to do when they take that affirmative act, or before, or maybe that's the first affirmative act they do, is to file a campaign treasurer appointment. A candidate cannot accept or spend money before filing a campaign treasurer appointment. And that sort of hooks them up with their local filing authority or the commission, depending on where they're filing. And they're on this filing schedule where every candidate must file semi-annual campaign finance reports. It's every January and July 15th. And if a candidate is opposed in an election, that is, their name and someone else's name are going to appear on the ballot for the same spot, they have to additionally file reports 30 days and 8 days before the election, and also 8 days before a runoff. For going back, I mean, for certain candidates, they can, if they say they're going to file on the modified reporting schedule, that is, they're going to spend less than $900 on their election or accept less than $900 on the election, they'd have to file the semi-annual reports, but not the pre-election reports. when a candidate no longer expects to be making any political expenditures or accepting any political contributions, they can file a final report, and that will end their filing obligations as a candidate. They may, depending on the office, still have filing obligations as an office holder, but they wouldn't have filing obligations as a candidate. But it also means they can't have further campaign activities, accepting money, spending money for their campaign. So district court and higher file with the Texas Ethics Commission, and they are required to file semi-annually for the duration of them holding office, whether they maintain their candidacy or not. And essentially your candidacy, your status as a candidate does not end until you file a final report. Statutory county court at law and probate court judges file at the county level. So it's the same reports that are prescribed by the commission, but filing authority, the repository for those forms are the counties. And there, as long as they're in office, if they file a final report and stay below $900 in office holder spending, they would not have to file campaign finance reports during the duration of their office holding. Now, so those are the general rules. And like I said, it was sunlight is the best disinfectant, except when it comes to judges, there's all these additional rules. And in 1995, the Judicial Campaign Fairness Act was passed. And this last legislative session, it went under substantial revisions that I think simplified the rules for judges. And this will apply from your statutory probate court and county courts at laws, going all the way up to the Chief Justice of the Supreme Court. Notably, the JCFA, Judicial Campaign Fairness Act, does not apply to a justice of the peace candidate or office holder. So for the purposes of campaign finance, a justice of the peace would not be considered a judicial candidate, but they would be subject to the jurisdiction of the Commission on Judicial Conduct and treated as a judicial officer for other purposes. The hallmark of the JCFA is campaign contribution limits. It's what separates judicial candidates from all other candidates under state law. Contribution limits apply. The first one we'll talk about is a per person limit, and that applies per person in connection with an election. And each election in which the candidate appears on the ballot is considered to be a separate election. So the primary runoff, in general, will all be separate elections and all have essentially a reset of any contribution limits. And that's a change in the 2019 legislation. Before, it mattered whether the candidate was opposed on the general or primary ballot. Now it doesn't. So each election is separate. The per person contribution limits are tied to the size of the judicial district. So at the top for statewide or judicial districts with a population of 1 million or more, it's $5,000 per person per election, going down to $2,500 and $1,000 for the smaller judicial districts. And these judicial district populations are set for the at the decennial census. In addition to these per person limits, there are aggregate limits placed on law firms. So the aggregate limits apply to what's known as a law firm group, and that's a statutorily defined term. And the law firm group can only give on aggregate up to 6 times the individual limit. And once that limit is reached, the aggregate limit is reached, any other person associated with that law firm who's in that law firm group could only give $50 to the judge. And a law firm group is basically, and the law firm itself, a general purpose committee that is formed or established by the law firm, and also all the lawyers, whether they be partners of counsel, associates, and employees and spouses of those people, all count as the law firm group. And when a judge accepts a contribution of 50, I think it went up to $90 or more, they need to put down the principal occupation and employer and name the law firm that that person's associated with. So it's up to the judge to understand what their limits are based on the information they get from their contributors. So to put it another way, there's a $30,000, $15,000, and $6,000 aggregate limit depending on the size of the judicial office being sought for the law firm group, and then $50 from anyone else from that group. Now, it's important to understand that this does not mean that a law firm could give $30,000 to the judge, right? The law firm itself, written on the firm account. The law firm is a person. So the law firm could give $5,000. Partner A could give 5,000. Partner B could give 5,000. Partner C 5,000 until 30,000. And then once members of that group reach $30,000 to the judge in total, then the next person who wants to give could only give $50. In addition to law firm limits, individual limits, you also have GPAC limits. So general purpose committees, a group of people that have as a principal purpose spending money in elections or accepting money to spend in elections. And the limit is $25,000 from an individual GPAC for statewide office, and then $5,000 for any other judicial office. Layered on top of that is an aggregate limit for general purpose committees. And you can see there are much higher limits, and it's a similar concept to the aggregate limits for law firm groups, where a candidate can accept up to, for statewide office, for example, can accept up to $300,000 in up to $25,000 increments from general purpose committees. And then once they hit that limit, any other GPAC that would want to give to them could only give $50 for that election. So that's limits on the amount that comes in. There's also temporal limits. There's only a certain time of the election cycle where judges can, or judicial candidates can raise money. And it begins 210 days before the deadline for an application on the ballot and extends 120 days after the last election where they're on the ballot. So what that looks like in practice, if you just take the 2020 election, someone running for judge on the ballot in 2020, in November 2020, could accept contributions beginning May 13th of last year. And if they make it to the 2020 November ballot, they could accept all the way through March 3rd of next year. This is for illustrative purposes because the cutoff dates are tied to the election, and because of the coronavirus, some of the election dates have moved. Some of those dates might change, but this is sort of the general default setup. If a judge is appointed to fill an unexpired term, it's slightly different, where they can begin raising, or sorry, not if they're running to fill an unexpired term, they can accept 210 days before the deadline for that ballot, or the date the vacancy occurs, whichever is later, and they have the same ending date. For judges who are appointed, they can start raising money the day they assume office, assume the duties of office, and continue raising money, campaign money, until 6 days after they've assumed the duties of office. And this is a change, again, in the 2019 legislation, where before, appointed judges could only raise money to offset office holder expenses. And it's changed to be more permissive to allow them to accept money for both their campaign or office holder purposes. Now, when judges have campaign contributions, there's also restrictions on what they can do with those that are unique to judges. They're limited, as this chart lays out, as to what they can give to other candidates or other political committees. They're not limited to what they can give to the party, which is a change again from the 2019 legislation, where they can give from their political contributions to a county or state political party, as long as that party provides them services. Before, it was tied to the pro rata share that candidates in that sort of county party were receiving. Now it's just you can give from your political contributions without limitation back up to the party. And also there's, for certain political committees that are affiliated with the county or state party, judges can use their political contributions for sponsoring or attending an event. And this was not the case before. They were just sort of stuck with those GPAC limits. So it's, again, a little more permissive here. Now, judges, people who run for office sometimes use their own money to fund that. And if they receive political contributions, can reimburse themselves for those office holder, I'm sorry, those political expenditures from personal funds. Judicial officers are limited, and their close family members are limited as to how much they can reimburse themselves for their campaign expenditures from their personal funds. And it's down to $5,000 reimbursement only for the smallest judicial districts. The biggest change from 2019, from the legislation in 2019, is voluntary expenditure limits have been repealed, and that's a pretty substantial change. Before, judges would have, when they first ran, they would have to say whether or not they're going to comply with voluntary expenditure limits, and if they said I am not going to comply, then the contribution limits for their opponents would be lifted, and the Ethics Commission would have to issue an order saying, for this race, these candidates, there are no limits for spending money and raising money. We don't have to deal with that anymore. The voluntary expenditure limits have been lifted, and they were set high enough that it really didn't become an issue. Almost every judge would say, I am going to abide by voluntary expenditure limits. What would happen, though, is if a third party wanted to spend more than $5,000 in an election, they had to provide notice to the Ethics Commission of that. And if we received that notice, we would have to suspend the limits for the candidates in that race who are not benefiting from that expenditure. So all it would take is someone saying, I intend to spend $5,000 independently to benefit candidate A, and that meant candidate B would have no more contribution limits. So this repeal gets rid of that practice. There's more prohibited activity or prohibited sources for contributions. Chief among them is the contribution on corporate, the prohibition on corporate contributions. This will apply to for-profit and nonprofit corporations and labor organizations. It generally will not apply to professional corporations, LLCs, LPs, and many other business entities. And the reason for that is just how the law is written. The law says business organizations formed under certain acts, including the For-Profit Corporation Act, cannot give contributions. And it just does not say professional corporations and the like. So most law firms would not be precluded from giving to candidates, judicial candidates, or otherwise. Also, for purposes of keeping track of the money, candidates cannot accept more than $100 in cash in aggregate from a single contribution during a reporting period. Judges cannot accept contributions in a courthouse. And, the money that's raised for elections or for office holder purposes is meant to be used for those purposes, and it's not meant to provide additional income for candidates for office. And so there's a law that prohibits candidates and office holders from converting their political contributions to personal use. So if the use of the campaign funds are not primarily in connection with your office holder or campaign activities, then it's going to be a personal use. The Ethics Commission issues advisory opinions, and one of the questions we get a lot is, can I spend my money in this way? And I won't go through all these, but I put together a list of all the opinions that I could find that dealt with judges and whether they could use their campaign funds to do one thing or the other. At the last meeting, a judge and aspiring podcaster had asked the commission whether he could use his political contributions to purchase podcasting equipment to do a podcast about the law and about judging to educate the public on that. And the commission said, part of being a judge is, part of your duty as a judge is to educate the public about the court systems, courts, and the law. And as long as you're using your podcasting equipment for that purpose, then that's a permissible use. So that's just an example of a recent advisory opinion dealing with the personal use of.
Mr. Titley, those numbers out to the right, are they the number of inquiries that were made by judges?
Oh, yeah, Chairman Beck, that's the number of advisory opinions. So each advisory opinion is assigned a number. So that's advisory opinion number 130, number 247.
Thank you.
Yes. Additionally, to the general personal use restrictions, there are specific prohibitions in statute for using your campaign funds or political funds to purchase real property, to pay for the personal services of a spouse or child, and to repay loans of certain close relatives. And also, a judicial candidate cannot use money they've raised for a judicial campaign to run for a non-judicial office. And likewise, a non-judicial officer or candidate cannot use money raised for that purpose for a judicial office. There's no anonymous contributions. Everything has to be kept with records and then reported. So you can't pass a hat or have tip jars. Also, judges, when they run, the judges who in Texas are elected have to navigate the idea about they're a public servant and they're also running for office. And therefore, there have to be laws that say you can't use your office or things that come into your possession for your campaign. And the Ethics Commission, an advisory opinion, said you can't use your government computer to prepare campaign finance reports or gather information for a political fundraiser. And they recently reaffirmed this idea in Ethics Advisory Opinion number 550, that public officials, including judicial officers, can't use government resources such as an public officer's office to create a photograph, video, or other communication for political advertising. Now, that's just a general overview of the laws that exist that restrict judicial campaigns and office holders. One thing that's not present in that presentation and not addressed because it's not addressed in Title 15 of the Election Code is the idea about, the conflict of interest. Can a judge hear a case from a lawyer or a party who gave that judge money? And judicial officers are regulated by the the Commission on Judicial Conduct that would address that. Most of them are lawyers that have certain ethical obligations under the State Bar of Texas, but there's not anything specific in Title 15 or the laws that the Ethics Commission enforces that speaks to that issue. So getting into this idea about campaigning in practice and getting into some of the numbers, when candidates file reports with the Ethics Commission, most of them are done electronically now. And so the report, you can look at a candidate's reports and it's a document into itself and you can read it and look at the data. But also when they file reports, it fills a database and that database can be queried and the data can be sorted to, hopefully provide useful information. And we see academics do that. We see journalists use the database to look at that. You see other parties looking at their opponents and political consultants sort of getting the lay of the land. The Ethics Commission, as a general practice, does not run general reports to look at general trends in the data. We might look at it for a specific purpose, like we're doing rulemaking, we want to make sure the rule makes sense and is addressing an issue. So I know there's a forthcoming law review article that looks at this data and as it relates to judicial appointments for criminal indigent defense and campaign contributions. But what I did what we did is we pulled together some of the data to look at the recent races to see how much money is being spent in elections. And I think that was communicated to me. So you're trying to get a sense of what does it cost to run to be a judge in Texas. So the first race that we'll look at is Texas Supreme Court 2016. There were 3 places on the ballot and there were 3 incumbents, total of 15 candidates. And just a note on the methodology, what we did is we pulled reports filed by anyone who had ballot application information in our system for this office, and we pulled all the reports corresponding with the entire fundraising period open to the judge or judicial candidate for the 2016 election. And you see that $4.2 million in total is raised, $4.5 million in expenditures, and $142,000 in loans. And the reason why expenditures can exceed contributions is incumbents can have money left over and they can apply it to the next race. People can spend their own money in an election and they have to report that. And also sometimes the way the reporting system is set up, some transactions can get reported multiple times. So for instance, if I use personal funds to make a campaign expenditure and then seek reimbursement, that would show as the initial campaign expenditure, and then my reimbursement shows a second expenditure. So that's the reason why the expenditures can be maybe overstated, but that's what the numbers show. When we break it down into averages, see on average, the candidates in that race raised $285,000 and spent $303,000. The next column over, there were a number of candidates who were on the ballot, but they raised no money and spent no money. So to see how that was skewing the data, we pulled those out and it raises it to 428. So of the candidates who raised money and spent money, it was $428,000 in coming in and $455,000 going out. And you can see there's a split between the incumbent and the challengers is how much they're raising in 2016. We go ahead to 2018, there's 3 places in the ballot, 3 incumbents, 6 total candidates, and no opposed primaries. So in the 2016 race, there were a number of contested primaries. In 2018, there were not. So this is looking at just that elections in effect. I didn't separate out primaries and generals for these numbers in general. Here you see pretty similar numbers. I think there's an increase in spending, but it's, on average, 300,000, 600,000, 500,000 being spent or being raised for these top flight races. Now, if we step over to the Court of Criminal Appeals, these are total numbers. So there's a stark difference between the Supreme Court and the Court of Criminal Appeals, both courts of last resort in Texas, and you see very different numbers. Again, here the averages is 20,000. If we pull out those reports for people who didn't spend any money, we don't count those. So people who are raising or spending money, it's about 44,000. And you see a split between incumbents and challengers in 2016. If we go up to the next election, 3 places, 2 incumbents, 8 candidates, very similar numbers again from 2016. Interesting here, though, is the challengers outspent the incumbents in this race. These incumbents did not really spend any money or hardly any money in this race for Court of Criminal Appeals. So very, very different numbers if you look side by side between Supreme Court and Court of Criminal Appeals. If we move on to the intermediate courts of appeals, what we did is we took, again, this is for the 2018 cycle. This is both primary and general elections, the entire cycle. We just took all of the people on the ballot, all of their reports, and you get average totals for money coming in and money being spent at 145,000 and 131,000. On the district court level, the average contribution is 50,000, and the average expenditure is 51,000 with $3,400, or sorry, that with also a sizable amount of loans for the total. Sorry, my video is cutting off the last column there. So yeah, it just 8,000 in average for loans for the district court level. So I mean, this is just to give you an idea of what people can do with the database and to give you an idea about the average money that's being spent at the different levels of office for which the commission has data. And with that, that concludes my prepared remarks. I'm happy to answer any questions.
Thank you, Mr. Tinley. Just one quick question. Does your office receive any complaints from the public about the amount of money that is being spent on judicial elections? And if so, what do you do with those complaints?
I'm not sure if we get complaints, just generally complaining about how much money is being spent. We focus on, we receive complaints about violations of law, which we would investigate if it's on the proper sworn complaint form. And I don't know the answer to about general correspondence having to do with money in general being spent in elections. I'm sure we have some, but we would just say, I believe we would respond that we've received their correspondence, but there's nothing that we can do about how much people spend. We just make sure that they're following the laws as I just explained.
Okay. Chip Babcock, I think you had a question.
Yes, Chairman Beck, thank you. Mr. Tinley, thank you, and an excellent presentation. What percentage of the contributions to judicial races come from either lawyers or law firms?
I don't have that data. That's something that we could probably get because every contribution has to have the occupation and employer. So we'd be able to sort that data, but I don't have that percentage handy. But it's something I could get to the commission for sure.
Okay, great. Thank you. I would personally be interested in that. Secondly, do you know whether the monies that are contributed and wind up in the hands of the judicial candidate get spent on things like contributions to political parties or things that are not directly related to educating the public about the qualifications of the candidate.
Well, so let me make sure I follow. I mean, I don't have the data on that, but a judge, especially after 2019, may give money to political parties. So they can give their own contributions to political parties, and that's permissible, and that would not be a conversion to personal use. I don't know how widespread it is. I don't have the data handy on that, but that's certainly permissible, and it wouldn't come under the personal use issue because it's expressly permitted by law.
Okay, I've noticed that there's some judges who do not have an opponent, either in the primary or in the general, are still out raising money. Any sense of what they're raising the money for?
You know, I wouldn't speculate, but but I would say that money that they raise can be used in a future election. So even if they don't need it for that election, they may be looking down the road for a potential election where they would be challenged.
Great, thank you. I hadn't thought of that. Thank you very much. That's all the questions I have, Chairman Beck. Thank you.
Hey, Mr. Tinley, I echo Vice Chairman Babcock's request. Could you provide us some data about how much money lawyers and law firms are contributing in these judicial races, particularly the civil judicial races?
Yes, I will do my best to get that information to you. We should be able to sort the data by office sought and by contributor or employer occupation to get you that data.
Great. Thank you. Any other questions of Mr. Tinley?
Yes, Mr. Chairman, Senator Birdwell.
Okay, Senator.
Thank you, Chairman. Mr. Tinley, one quick question on the appellate charts that you put up. The delineating factor, the Supreme Court's, Court of Criminal Appeals, Supreme Court, and the district judges have a set number of judges. Did you find any distinguishing anomalies at the appellate level, given the differences in the number of judges on those respective benches, i.e., the Dallas court has 13 judges, the Fort Worth court has 7, Waco's got 3. Were there any distinguishing anomalies because of the size of the benches in the respective appellate courts?
You know, I don't know. I did not get into that level of granularity to look for why there were differences, merely sort of top level looking. And I certainly, if that's of interest to you, I certainly could look into that.
I don't know what would be different, but I wanted to see if you had looked at anything that would make them statistically different because of, like, the Eastland court, very rural court. But my concern that I'm really getting at is in like the previous judge's testimony, Judge Timmer, when she talked about the 3 district courts, my concern for the appellate courts is, like, the Waco court has 18 counties, and Waco and College Station are the 2 larger markets, but there are lots of other people in those 18 counties. Whereas the Fort Worth court has 14 counties anchored in Fort Worth. And what you can end up with, this is probably more a redistricting of the courts question than it is a fundraising question, but you end up with Tarrant County dominates the other 13 counties. Whereas in the 10th Court of Appeals in Waco, the 2 counties are competitive, but the other 16 counties have enough rigor to them that they're not outweighed in which judges are, whereas the county bar of Tarrant is the dominant force on the 2nd Court of Appeals elections.
Yeah, that's a very good point. And Senator Birdwell, I'll be the first to say, you know, just taking the mean, taking the average of appellate courts, it's very limited in what it can tell you as by way of data. But I didn't want to get too into the weeds, maybe take direction from the commission.
I know it is granular, and I hope I'm not wasting the commission's time, but that when those charts came up, you know, because of the natures of the differences of the judges and what metropolitan area they have contained, that can be statistically significant differences.
I'm sure, yeah.
Mr. Tinley, will you try to drill down on that a little bit more and perhaps report back to us on that?
Yes, I can do that.
Thank you. All right, thank you very much for your presentation. It was very informative, and I appreciate the work you've done in putting these charts together. So thank you very much, and we look forward to you getting your answers on these other questions.
Okay, very much. Thank you very much. You're welcome.
Okay, thank you. Okay, that brings us to our final presenters this morning, which is Dr. Dottie Carmichael and Dr. George Nafal from the Public Policy Research Institute at Texas A&M, who are going to talk to us a little bit about how they might be able to help us with respect to the development and formulation of our final report. So Dr. Carmichael and Dr. Nafal, you're on.
Thank you. And Megan was going to help me with the PowerPoint, I believe.
Yes, we're going to share it. Just a second.
Wasn't brave enough to tackle that on my own.
Okay, it's up.
Okay. Well, first, I just want to thank you all for the opportunity to contribute to this important project. My colleague, George Nafal, who will present in just a second, and I both recognize the impressive experience and stature of the people on this committee and the importance of the issue being considered. And so we're honored that Megan invited us to present today. And we're going to tell you as quickly as we can a little bit more about our experience and then listen to how we might be able to help. So advance to the next slide, please. Just to give you a sense of who we are, the Public Policy Research Institute was created in 1983 by the Texas legislature to conduct research informing policymaking. So today we have 36 full-time research staff. We have PhDs in economics, political science, public health, and our research teams have extensive applied research experience, much of it supporting policy development in Texas. We have $150 million in funding over the years, and in any given year, we have between $8 and $12 million roughly in externally funded projects. Okay. So the major domains in which, well, I think we all like to say at PPRI that if there's a policy issue that impacts the lives of people in Texas, that we've probably done some kind of study on it. Other areas in which we do research are criminal justice, education, healthcare, workforce development, and other areas as well. These are some of the majors. And then George and I focus primarily in criminal justice. So move on to the next slide, and I'll give you a sense of what our technical capabilities are. We do survey research, we do data analysis, a lot of it being large archival state agency level data sets. We've done statewide mental health record analysis as an example. So some of these are massive. We do program evaluation, policy analysis, and provide data management and technical assistance services for a number of state agencies, including the Office of the Governor, and as I'll explain later, the Indigent Defense Commission. So we kind of help some of the agencies sort of keep the administrative wheels turning with technical expertise. Some of the groups and organizations that we've worked for, many federal agencies, including National Institutes of Health, the Department of Justice, the CDC, the National Science Foundation, and then you can see the array of state agencies that we've done work for, including the Office of Court Administration. And Arnold Ventures is a foundation shown in the lower right, but we've done a number of work, George in particular has done work with a number of other foundations, including Robert Wood Johnson, the Caruth Foundation, and others. So we have a broad variety of different types of organizations that we do research for. Okay, so I'm just going to walk through just to sort of a real nuts and bolts feel for some of our policy relevant research impacting Texas. One of our larger and more impactful studies was the 2011 Breaking Schools Rules study, and that turned out to be nationally significant. It was really the first definitive study showing evidence of a school to prison pipeline. We followed 1 million students for 6 years based on the TA and PEIMS data and the juvenile probation data combined. So just combining those data sets was monumental. And from there, we showed that school suspension and expulsion increases juvenile justice contact, and that the most damaging effects are on youth of color and those with educational disabilities. Our partner in this effort was the Council for State Governments, And so that's part of what boosted our funding and boosted our impact. But in Texas, it was particularly impactful as we had subsequent legislation that decriminalized misbehavior at schools. And following that legislation, there was an 83% decline in the number of students that were issued law enforcement citations at school. Legislation was also passed that reclassified truancy from a criminal to a civil violation. And now schools are required to offer preventive interventions before taking legal action for truancy. So some major policy changes came from that study. The center report there symbolizes another defining set of research that we've done for the Indigent Defense Commission. So since the passage of the Fair Defense Act in 2001, PPRI has had a research program supporting the Indigent Defense Commission and their efforts toward reform. As one example, the 83rd legislature mandated a study to determine how many cases a court-appointed attorney could carry while providing reasonably effective legal representation in misdemeanor, felony, juvenile, and appellate cases. And the results of that study have been key to the reform development of guidelines for setting a standard of the number of attorneys a jurisdiction needs to have to manage their caseload of appointed cases, and also the amount of funding that would be required for constitutionally meaningful counsel. So it's really helped improve planning and budgeting around quality indigent defense. Other similar examples of studies we've done for the Indigent Defense Commission, we've compared the effectiveness of public defender attorneys compared to private appointed counsel. We've evaluated the state's innocence investigation clinics at our publicly funded law schools. We've showed the improved quality of representation in death penalty cases provided by the Regional Public Defender Office for capital cases. We've examined holistic defense by looking at the benefits of specialized staff to help in the defense of people with mental illness. And so over the years, we've done about 20 studies in this area that have, and this body of research is still ongoing. And the third report there, it represents a study that we did recently for the Office of Court Administration. And well, in 2016, the Texas Judicial Council's Criminal Justice Committee led a bipartisan effort recommending validated risk assessment as an alternative to money bond when deciding pretrial release. So in the study, PPRI was asked to conduct, to assess the potential impacts of a risk assessment by comparing Tarrant County, which has a financial bond system, and Travis County, which uses a risk assessment to decide who to release pretrial. And the study showed that the validated risk assessment is a tool that judges want and need, that a risk-based release does a better job than money bond for deciding who can be safely released pretrial, and that it's fairer for defendants and it can be cost-effective. And in terms of policy impact for that study, the Office of Court Administration, you may know, subsequently made this, the Praise Texas, the pretrial risk assessment tool available for Texas counties online. And the study has also informed subsequent efforts toward bail reform in the legislature. Okay, new slide, please. This just illustrates a couple of ongoing current projects that we have. The first is, I mentioned we've done a lot of work with the Indigent Defense Commission. So one of the foundational things we do for them is we've built and maintain their online indigent defense reporting system. So this started in 2002 when the commission's first executive director, Jim Bethke, needed a tool to monitor the implementation of the fair defense. He was the first person to have to set up all these systems. And so he wanted to have it all online. And through this system, counties report the number of court appointments and expenditures by court. Their local indigent defense plans are posted so that even though there's a lot of discretion how that's done locally, everyone can see what counties are doing. And there's also a reporting of the number of cases assigned to individual attorneys, which helps to monitor that caseload issue.
Dr. Carmichael, let me interrupt for just a moment. In the interest of time, first of all, I want to thank you for for being here and being willing to share with us some of the projects that the Institute has been involved in and so on. I guess the question I have is, walk me through how you think you could help us, you and your staff, if we asked the Public Policy Research Institute to assist us in the development of a report, development of our recommendations. Walk us through, if you would, how you would go about that.
Okay. I think the first and most important thing would be to begin by listening to the work of this committee so far. And so reviewing, and basically extracting from the prior meetings, what are the issues of concern, reading the charge documents that define your work, and trying to understand the scope of the issues that are being considered. And then I think it would be backing that with review of recommendations from other jurisdictions based on what has articles in the literature there. So there'd be the academic literature, there are advocacy groups that have put time into cultivating arguments on either side of the issue of judicial selection. And so trying to look at focusing on what we know the committee's objectives are, expanding that to a larger domain of literature and policy and external perspectives, and trying to integrate that, feeding that back to the committee along the way so that you would know what track we were on. We would probably want to agree on some reporting intervals and getting feedback as we build out our argument together, because I think at the end of the day, it's your story that we're telling.
Yeah, I think, as you mentioned, the so-called charging document, we're instructed to look at the pros and cons of all these various alternatives of judicial selection that the legislature put in its piece of legislation. So we're going to have to address every one of those in one form or another, which means we're going to have to look at the pros and the cons of each of these. And that's a major effort. And so my next question really deals with the timing of this. I think Senator Birdwell at our last meeting basically raised the issue of, when are we going to get started on addressing some of these pros and cons and kind of what the views of the commissioners may be. So how much time do you and your group need to come up with what will be a final draft report? I mean, we have a deadline of December 31. Now we've got to finish our report and submit it to the legislature. So my first question is, can you do that within that time frame? And secondly, how much time do you really need?
Well, thank you for giving us notice in July. We've gotten much shorter notice on projects like this before. I think it's a question of, how, I think we could do it by December. I think I'd like to have a draft up maybe a month in advance. So that bumps us back to like maybe 1st of December, end of November, to have a document to get your feedback on. I think I would look at it as a coding exercise almost. I mean, we're reflecting your perspectives. We're first starting with what this committee has brought forward as being important. So the first thing we would do is just extract from your meeting notes what your priorities are, and then build out around that a literature search and talk to other, for example, I think it'd be helpful to potentially follow up and get some clarity and precision on the presentation from the Ethics Commission presenter that just completed his presentation. So following up with selected external resources. And so I guess to answer your question, here we are in July. How frequently are you guys meeting?
Once a month.
Once a month.
In our regularly scheduled meetings.
And then there are the committee notes, and that gives us additional insight.
Right. And then we will be having public hearings in addition to that.
When will those be? Do you know?
Well, the first one is at the end of this month, and the others aren't scheduled yet because we want to wait and see how these Zoom public hearings actually work in practice.
I mean, I think we just have to, all of us probably, do the best we can around this, right? I think we'll try to stay on top of it, try to start pulling the themes that need to be articulated in the report together, and then, you know, try to have them in a form we can pass back to you by the end of November.
Okay, and then one last question. I think Vice Chairman Babcock has a question, and that is cost. Do you have any idea what a project of this magnitude might cost?
Well, we sort of touched on that with Megan and got some insight into sort of what was reasonable and what we've done in other similar studies. So, you know, I didn't realize there were public hearings, and that could take a little bit of additional time to sort of sort through all those comments and stuff. But I think probably in the neighborhood of $50,000 to $60,000, something like that.
Okay. Chip Babcock, you had a question.
Yeah, thanks, David. One of the things that I think we need to know is somewhat fundamental, Dr. Carmichael and Dr. Nuffel, is whether or not the citizens of our state and frankly, the users of our justice system outside the state have confidence in our system. And a subset of that is, do they have confidence in the way we're selecting our judges? Yes or no? That sort of underlies our whole purpose in studying this issue. So first question, is there a way for you to measure that? And if so, how would you go about it?
In the time available, unless, you know, I'm missing something, it'd be pretty tough to do a rigorous study of like how that would accurately reflect the proportion of support for different, you know, for the judiciary and the selection model that's currently in place. I mean, I just think that'd be very challenging given the scope of our other work and the timeline. That said, I think we've got some resources to bring to bear more broadly. One is Megan's told me that you're doing a survey of other court administrators in other states, and we've got judicial election data from November coming up. So I don't know exactly, that won't tell us about public, to the extent that it would tell us who gets down to that place on the ballot. I mean, it would show the commitment to, you know, making the judicial vote, especially in this first year with no straight party ticket option. So that would be one indicator. But as far as like collecting original new data, I mean, some type of survey of some specialized audience might be possible. Some focus groups might be possible. You know, there might be ways to kind of get at it in a short form way, but we'd have to give some thought to how to do that within the timeline.
All right, any other questions by members of the commission? If not, Doctor, thank you so much for your help and your effort, and we will be back to you, albeit shortly.
Sounds great. Thank you for the chance.
Thank you, doctors.
Okay, members of the commission, just a few other announcements before we adjourn. In terms of our next meeting, which is on August the 7th, we currently have Judge Martin Hoffman, who has been reelected multiple times, most recently in 2018, who will be providing us with his views and thoughts regarding the way to select our judges in Texas. We also have Gary Bledsoe with the NAACP, who will be appearing before us. And then we may have some additional presenters at the same time. So I just want to give you a heads up on that. I want to remind you also that we have a public hearing in Corpus Christi that is on July 29 from 10 to 12. And I want to thank Representative Todd Hunter's office for their help in helping us put this together. One last item I wanted to mention, the issue of board certification and qualifications have come up repeatedly. And just so you know, we have in excess of 100,000 lawyers in the state of Texas, and less than 10% of those are certified in their particular area of practice. So we have a very small percentage of our total number of lawyers in Texas that are board certified. So those are all the items that I had to bring up at our meeting. Does any other commissioner have anything else you'd like to bring up? Now's the time. any subject you'd like us to address, any speaker you would like us to have invited to make a presentation at our meeting.
Mr. Chairman, one possible organization would be the 2036 Commission. It's a great group of individuals across Texas who are looking at the future of Texas on its anniversary in 2036. They've got a lot of experts going through all the data about school finance, but one of their areas is the justice system. So I think maybe that's somebody we might want to reach out to and see what kind of resources they could bring.
Yeah, Chief, is that Tommy Luce's group?
Yes,
Okay.
it is.
Okay, good point. We'll contact them and see if they'd like to make an appearance. All right, anything else to bring up before we adjourn? If not, I want to thank all you commissioners again and your staff for making yourself available during this difficult time. So have another beautiful day in the pandemic. Thank you so much.
Thanks, David.
Thank you.
Thank you, Chairman.
Bye.